Yesterday marked the end of the Supreme Court proceedings. The emotional roller coaster that we witnessed that day was indescribable. In the one hand, supporters of Azimio thought now this is the smoking gun, and that the Kenya Kwanza people's spirit were dampened, only for them to come back very strongly to discredit that evidence. What, in your view, were the highlights of Friday's proceedings, the climax of what we have been waiting for, round 2 of Raila versus Ruto? That is our topic of today, ladies and gentlemen. What are the highlights of Friday's proceedings? Before we delve into that topic, I do kindly urge you to subscribe, click the notification bell so that you are notified when we post these kind of videos. This is the Nationalist Show with Kennedy Bongo. I'm going to host you and try to describe and educate you on the highlights and what they mean to the case. Now, number one highlight which I noted, judges asked questions. The reason why judges ask this question is so that the council may assist them in making their decisions. And therefore, questions posed by judges are very critical to answering or to writing the judgment eventually. So did counsel from both sides answer these questions as asked by the judges? The first highlight which I noted, and this one came from the respondents themselves, was the question with respect to gazettement of Chebukati as the presidential returning officer. The question was asked by Justice Ouko whether there was a resolution to that end. The reason that question was asked is because the good judge wanted to know whether the commission acted as a unit as per the constitution, which requires them that such decisions be made as a unit. Then what was the answer of counsel? Counsel did not answer that question. He proceeded to quoting the Constitution, actually quoting the Constitution, Article 130.10 to be specific, which is really unrelated to what was going on. Because Article 138.10 relates to declaration of results. The question was whether there was a resolution to that effect. To that effect. The question itself did not have any constitutional bearing, and therefore my wonder, why did good counsel decided to quote the Constitution? So he was answering that way to avoid the question altogether because there was no such resolution, and therefore the mind of the judge has been left intact that there was no that kind of resolution, and that may impact Ruto's case and strengthen Azimio's case, and especially with the type of evidence that the other 4 commissioners are bringing, that Chebukati has been acting unilaterally. Number 2 highlight, on the question of multiple sense of the word IEBC, that at what point, or rather commission, the question was again posed by good justices on Thursday, that how would you know in what context to describe that now the IEBC is acting in this particular sense or the other? Then counsel responded that it depended on context, but then failed to provide context to the good judge on what context Chebukati announced the results. And this, I find, was a very good opportunity for them to explain the 3-tier levels of how the IEBC acts, from the polling station to the constituency tallying center, and finally to the national tallying center, where the presidential results are again verified, tallied, and then given to the commission's chairman to declare. That was a good opportunity, which I think they missed. They have to explain how the commission mutated in each circumstance up to the point of declaring the results. And I believe that was asked by Justice Njoki Ndumu. Because really, in the mind of Njoki Ndung'u, the person of Mr. Chebukati has been presented as all powerful. He can do whatever he likes. And the base by Counsel Karori with respect to interpreting Article 138 3C was very important, and I thought that provided them with a good opportunity to really hammer that point home, which I think they failed to provide by failing to give context to the question. Number 3, Mahat Counsel, while responding to the issue of discrepancy, again proceeds to lecture the court on the exercise of what ought to be. He says that discrepancy can be explained rather by stray ballots. Curiously, however, he concedes immediately after that that they do not have the exact number of stray ballots. The question that the good justices wanted to know is whether IEBC could or has or can explain that discrepancy, not how they can be explained. Apart from saying how they can be explained, you really need to provide context how you can explain in this particular case. That was not given. Essentially, counsel want the Supreme Court to assume his position as factual and true without any actual statistic from IEBC. Again, that was an educational exercise rather than responding to the real question that was really pricking the conscience of the good judge. On the issue of turnout, and I think this is now the elephant in the room, that the question will really revolve on the issue of turnout, and this we highlighted yesterday in our video. The moving target, you saw Azimio now unleashing the Honorable Otiende Amolo coming in hard really to hammer that point home, stating with the words we again used in one of our videos, that's the issue, our yesterday's video, that the issue of turnout, you cannot really pinpoint where is it, which is the number. So when he came on the issue of moving target, Mahat boisterously told court that the issue of turnout does not matter. And I don't think that is what court wanted to know. Court wanted to know the exact number of turnout by telling court that no, that does not matter. It's really not taking court for a ride, because to the mind of the judges, it is a critical aspect that they really want to use and really want to know. Because if you can't know the turnout, then how can you trust the results? This again was really a curious argument coming from, or response coming from the respondents, particularly the IEBC. On the issue again of 1.6 million voters, which I believe again Justice Ouko asked, who voted after 9th, or that information or the information kept in coming from Kimskit after 9th or close of voting on the 9th. Again, it was quite curious because I heard when Mahat answered, and I believe it was a very damning answer to their case. He said that due to network issues, that information was not relayed in time. However, the Kimskit contains or retains that information up to 2 hours. Up to 2 hours. You can do the math. After the close of polling, then if there is no network, that information is retained up to 2 hours. My first question, what happens when that 2 hours lapses, or the 2 hour period lapses, without network? Is that information lost? So he left the judges with more questions in their heads than really answering the actual question. But that is not even the point. The point is the streaming of voting kept on coming. This information kept on coming even after 10th, after 9th rather, of August. That is what Okia was again came and hammered that home, that there was voting. 500 over 500 and people voted on the 10th of August. Where did that information again come from? And why didn't they respond to it conclusively? And I believe that is another area that can tilt the decision of the judges. The issue of turnout and the issue of now voting beyond the close of polling. And I think if that happens, the Azimio side, if eventually the court finds that it cannot really ascertain, the Azimio side must be very, very grateful for Okia Omtata, Senator Busia, for hammering that point home for them. And then on the issue of why Chebukati could not wait for another day to announce the results, Professor Kindiki answered this question, and I believe quite arrogantly, because it did not help both court and himself. He said particularly that I find that the political situation could not allow any form of consensus. And therefore he proceeded to answer. But the question was really simple. It was one day, you already have the results. Why couldn't you at least find consensus first? And then, proceed and declare. Again, I find this to be just a continuation of a political narrative than a cogent and legal-based excuse to what happened on that day at Bomas. And now this is another issue that is going to impact the case, the scrutiny report. That was now, I believe, another big highlight of the case. So it's making this case look more complex than we really anticipated, and really making us now more believable, because we told you it would only get murkier. The scrutiny report largely showed that votes that were counted matched the recordings of the Form 34As. That is the counting bit of scrutiny, because scrutiny is beyond just counting the votes. It is beyond just counting the votes. Let's say the principal objective of scrutiny is to determine whether the electoral process was transparent, accountable, and verifiable. And you believe, as you know, Azimio is alleging that that process was not accountable, transparent, and verifiable. Those are the allegations. So what does the report mean to them, especially in terms of numbers? In terms of numbers, then it supports Ruto's case that I have the numbers of all that. Ruto, I believe all the numbers matched. But now you have to take this argument further a bit. You're looking at how some of the materials, because scrutiny involves looking at the materials, including the ballot box itself, the seals, the cover, because these are critical election materials. Do the serial numbers still match that was with those that were recorded that were used rather at the polling station? Do they still match? Some of these were found not to match. Then the question would arise, why then would we believe, even if then the Form 34A matches with the votes counted therein, then how can we then believe if somebody opened it? Because you're not supposed to open it except by order of the court. But then if you have these seals, a different seal from that which was used without order of the court, then how can we believe any of those things that came from there? This is another aspect that I felt the Azimio team, particularly the Raila Odinga side, failed to deal with properly. And I liked Counsel Willis Otieno tried to hammer it so much, and Counsel Awele also tried to hammer it, but the whole aspect was diluted by Azimio coming with its own report to court, because it shows more or less they acted like the four commissioners. They were involved in the process. They should have used that report by the registrar to attack the process of IEBC. And therefore, I believe the report, the scrutiny report, a little bit is not really good for Raila side, and strengthens very, very much and crucially Ruto's averments and IEBCs. So how will the court will deal with those and the issues of constitution and the evidence that is being presented, we will see on Monday. How will they separate numbers? Because the arguments will be made by counsel that if the process was flawed, did not conform with the constitution, the product cannot be trusted. The other side would say, okay, there was substantial compliance, and therefore the result should not be interfered with. Then another elephant in the room, and I think this I started with when I gave a pointer to it when I began my address to you today. The rejoinder by Julie Soweto, counsel for Raila. That rejoinder raised a lot of buzz because we thought finally, at least the Azimio people, that there is the smoking gun. Carmargo has been found deep inside inside the servers, only to turn out that it was mere picture, an overlay of his name. But again, it raises more questions than answers, if you must ask me. And I think counsel from Azimio side did not really address this conclusively, because we are told that this person is for maintenance. What is his name again doing in election materials? I found that the respondents tried to explain this, and that point may not now be neither here nor there. And also the issue of two Kimskit having the same serial numbers. They came with those and they provided them before court. I believe, in my view, those are the major highlights of yesterday's proceedings. As judges now retire to write their judgment, it is also our duty to again inform you on how the judges may answer the 9 questions and what they will consider. That will be in our next video. So thank you very much. Like this video and share. Thank you.